So I have this little chart here to show you the probate flow. With probate, I just want to explain probate in general because it helps for you guys because you're going to be in it for only for the real estate portion, right? But the big deal here is to just understand it so you know where we might be at when you're doing what you're doing. The first thing that you need to do in probate is lodge the original will with the court. If there's a will, you got to lodge it with the court. It has to be the wet ink signature will, not a copy. The original is lodged with the court. If you cannot find the original will and you have a copy, then we can do what's called prove it up. We have to do more work. It costs more money. It's not as easy and it's not guaranteed. But basically, when you try to prove a will up, you have to pull in the witnesses, get them to sign affidavits saying that, they were there, they witnessed the guy or girl sign the document and it's his or her handwriting, etc. You also have to have the death certificate to open probate. So sometimes, it takes 2 to 3 weeks to get the death certificate. Sometimes it takes a lot longer. If it was a murder or a suicide, it takes much longer. A lot of times we can use the coroner's report or a letter from the coroner to open probate because a lot of times I have one that was just somebody passed away in their house and it took 8 weeks to get the report on it, but we used a letter from a coroner to open up the probate. First thing we do when we open probate after we lodge the will is do the petition to the court asking them to appoint somebody with authority on behalf of the estate. So to appoint an administrator. It's an administrator or it could, executors if you have a will. Administrator just encompasses executor and non-executors, but generally an administrator needs to be appointed. Until that person's appointed, nobody has authority. And I always say this 500 times to my clients because literally you do not have authority to sign a listing agreement. You do not have authority to rent the property out. You do not have authority to do anything. You can't go to the bank and get the money. You can't have no authority. The bank's not going to talk to you. Nobody's going to talk to you. So that process, once we petition the court and we file the petition, right now, thankfully, it's faster. So it's usually 5 weeks to get the hearing on the petition. 5 weeks from there. Now, there are now ways, thankfully, because the court is trying to make this faster. There are some times in summary administration where you can do what's called a stipulated petition and you'll get it back quicker, 2 to 3 weeks. Otherwise, we're looking at 5 weeks generally to get appointed. Once you get appointed or your person gets appointed, then the clerk will issue what are called letters of administration. And that is what you guys care about because you need the letters in order to have them sign the listing agreement to sell a house. Until then, you can't do it. Wait for the letters. Once you see the letters, then your person can sign the listing agreement. Put the property up for sale.